Hello, I'm attorney Scott Lesowitz, and I'm here to give you some interesting legal news about a trademark infringement verdict that was handed down in federal court in Manhattan on February 8th, 2023. So in that case, the famous maker of luxury goods, including handbags, Hermes, had sued one Sonny Estival, whose fake trade name was Mason Rothschild, and the court used that name, Mason Rothschild. I will not, because it's not his real name, and he has nothing to do with the Rothschild family. The jury found him liable of trademark infringement and awarded Hermes $133,000 in damages. Before giving a brief summary of the case, I imagine a lot of viewers right now are wondering if I'm covering this because I used to be a model for Hermes. I'm sorry, I'm being informed that nobody actually might think that. I'm sorry. Getting back on track here, the defendant, Sonny Estival, had created NFTs of slightly altered images of Hermes handbags that he had added faux fur to. And Sonny Estival had sold those NFTs under the name Meta Birkins. Estival had as much connection to Hermes as he had to the Rothschild family. None. So Estival sold 100 Meta Birkin NFTs, and the total sales of these NFTs was over $1.1 million. Yes, the average Meta Birkins NFT had over $11,000 in sales. Let that sink in. So Hermes, unsurprisingly, wanted to get in on this NFT game, and it sued Estival for trademark infringement and related claims. Hermes did not sue him for copyright infringement. So trademark law is focused on protecting consumers from confusion regarding who sold, distributed, or endorsed a product or service. It is not about protecting creators' creative expression. That is for copyright law. So Estival moved for summary judgment. That means he filed a motion in which he argued that even if Hermes' position was taken as to all the genuine factual disputes, Estival would still defeat Hermes' claims as a matter of law. If the court had granted the motion in full, Estival would have won without a trial, but the court denied the summary judgment motion in full. In ruling on the summary judgment motion, the judge agreed with Estival that he was potentially entitled to additional free speech protections under the First Amendment because it was artistic expression when he made these NFTs. So the judge explained that there would be two scenarios under which Estival would not be able to prevail on a free speech defense. The judge stated, quote, specifically, an otherwise artistic work is not entitled to First Amendment protection under that test if the plaintiff can show that either one, the use of its trademark in an expressive work was not artistically relevant to the underlying work, or two, the trademark is used to explicitly mislead the public as to the source or content of the underlying work, end quote. The judge further explained that, quote, the artistic relevance prong is not met where the relevant trademark was chosen just to exploit the publicity value of the plaintiff's mark. So the judge then ruled that Hermes had sufficient evidence to potentially overcome a free speech defense under either scenario. Therefore, it was up to the jury to decide the factual questions regarding the application of the legal requirements for a First Amendment defense. And of course, the jury ruled against our fake Rothschild and found him liable for $133,000 in damages. While on paper, it would seem that Mr. Rothschild still made a profit, I assume that after fees and costs are factored in, that he did not. So in conclusion, please don't sell NFTs that are slightly altered pictures of famous handbags. With that, that's all I got. Please like and subscribe and support this new channel. Very much appreciated.